All right, kids. This is a video that is there to help you learn about how courts are structured. We are going to hit up a couple of different topics, but we are going to figure out where cases go from the Court of Originals jurisdiction to the Supreme Court. And this is here to help you get ready for us to deliberate over a case in class. Remember that this has a lot of words on it, so I will take short breaks at the end of each slide for you to be able to catch up and to take notes as necessary. First stop here, we're going to talk about some of the kind of overarching themes here that are significant for us to know about the courts. The first thing is that most courts, when we're talking about federal courts, are referred to as Article III courts, meaning that they are either the Supreme Court or they were created by Congress as a court that feeds into the Supreme Court, that deals with most federal issues, most federal laws. And if it's an Article III court, it's going to be staffed by justices who have two components. Number one, they have a life tenure. And number two, they have a guaranteed income. Their income can be increased, but it cannot be decreased throughout their lifetime. This is created to make these men and women independent of the political branches, that is Congress and the president. Obviously, we should recognize that they are appointed and confirmed, appointed by the president and confirmed by Congress, and they can be impeached, but their kind of appointment and impeachment is not supposed to be necessarily a political issue. It's really, are they doing something that's showing that they're incapable of performing the general functions of a court justice. So with that in mind, it is important for us to remember that presidents really care a lot about appointing the right people, because they will not be removed for political reasons, these individuals. So we like to see young justices who have easy to identify, although they have to be nonpartisan when they're questioned by the Judiciary Committee in the Senate, easy to identify kind of track records that make it much more likely that this candidate turned justice will make sure they protect the president's legacy. So they all exercise something we know called today judicial review, which is a term that goes back to the 1920s. It is not something you're going to find formally in the Constitution. It's not formally it's stated. It was kind of in its infancy during the founding of America. We see Madison kind of complaining about the fact that there's all these different courts and there's all of these different legislatures, and we can't really tell which court is supreme, nor can we tell which laws are supreme. In a lot of cases, Madison writes, there's this problem with laws that are contradicting each other at both the Articles of Confederation, like the Congress level, and at the state level. And the courts, sometimes we have a hard time figuring out who has jurisdiction or who has the right to hear certain cases. And so we have these confusing, often contradictory decisions and laws. And so the way that the courts are structured is to be able to promote having one court be able to pass judgment over all others, and that is the Supreme Court. However, this concept, which you are not going to see judicial review in the Federalist Paper 78, is controversial. We do see it practiced for the first time. It's going to take some time by John Marshall, the third Supreme Court Chief Justice, in Marbury versus Madison. He's going to strike down a portion of the Judiciary Act of 1789 in order to establish judicial review, which is kind of a bold move, but also to do it in such a way that enables Jefferson to still feel like he's winning. And Marshall and Jefferson have a great backstory. They're cousins. They hate each other. And they both serve in the government at the same time in often contradictory roles. But we don't see judicial review used again until Dred Scott v. Sanford, where we're going to nullify or strike down portions of the Northwest Ordinance in order to determine that Dred Scott, his freedom is not really actually a thing. It will be used for the first time on states, and this is incredibly controversial at the time in a case called Fletcher v. Peck, and that is also under the Marshall courts. And it was just the whole idea of the courts striking down a state law was so unpopular that we actually corrected the Constitution with the 11th Amendment in 1794 to try to rein in the ability of the courts from suing or I should say, um, undermining the state's sovereignty. And so now the 11th Amendment prevents civilians from suing the state's sovereign immunity. That's legal protection against the states. They can't do anything wrong, so you can't sue a state in a federal court. Um, so, we've got some back and forth here, and judicial review tends to be at times another, version of controversy that we sometimes can't escape. But we are able to use judicial review because of this concept of precedent. When Marshall and his friends established judicial review, although of course it wasn't called that in the case in Marbury versus Madison, he's essentially creating a tradition, and that's what a precedent is. It's a tradition that looks at cases with similar instances and allows justices to make a determination about how to decide that case in conjunction with the traditions that are out there. And so we see that this idea of judicial review is a precedent, it's a tradition, and it's employed not a ton, not as much as you might think, but it is employed from time to time, and the reason why it's able to be employed is because of those life terms and because of guaranteed income. So courts of original jurisdiction are where we're going to start our little journey here. And if you were to have a case that was a federal law, like you were brought up on some federal violation, maybe you, I don't know, tinkered around with a mailbox in a way that's illegal because that's federal law, you would start in a court of original jurisdiction. And that is a court in which you are going to hear cases. The judges are going to hear cases, and they are going to determine guilty or not guilty, or help determine guilty or not guilty. If there's a jury, they'll help out with that too. So these are Article 3 courts, these courts of original jurisdiction in the U.S. circuit, or in the U.S. court system. We call them the district courts. There's one in Alexandria that is right by the Beltway. And that court of original jurisdiction is going to hear both that's criminal cases are violating federal law brought by a district attorney, and civil cases. Those are lawsuits for damages brought by individuals or groups on other people. So they will hear both of those, and they will make determinations about winners and losers, guilt and innocence in the district court. There's some things we should know. We cannot force the courts often because of tradition. Again, this is precedent. It's difficult to force the courts to always hear things that we want them to hear. And so often in class, I've heard students ask, well, why don't we have a case here about the War Powers Resolution, for instance? It seems like it's unconstitutional based on other cases like INS v. Chadha that said that legislative vetoes are unconstitutional. So why are we still employing this? And the reason comes back to this 4 different components to what makes something justiciable, right? Which makes it able to be taken to court. So I'm going to go through them in reverse order here because they're a little bit easier to understand that way. The first one is ripeness. Ripeness has to do with does the court have the allowance by law? Do they have the authority by law to hear a case? And we call that ripeness. If they don't have the authority, then they can't hear the case. This is why you don't see federal district courts hearing state law, because they don't have the legal authority to hear that case. It has to go to the appropriate court. Next is standing. Standing, you have to prove that you are actually being injured by a law. And if you are being injured by a law, then you can't sue. So for instance, if I wanted, if we passed a law that had to do with women having children, you wouldn't find the person bringing the case, the person whose name is in the case, to be a man. And the reason is because if we're dealing with childbirth and something that's in particular having to do with the right to having a child, that's sometimes called the right to predetermination, then he doesn't have standing. He can't have a child. We're talking about someone who has the sex of a male, not necessarily a gender. So another thing is mootness. If the case has been dealt with, it's been kind of put to rest. It's no longer relevant because time has come and gone, and it no longer makes any difference. Or if it hasn't become something that is actually injuring somebody, then you can't go to court for that either. So um, let's say you wanted to, question a regulation that was put out by the Environmental Protection Agency, and you were, waiting for your day in court, but somehow the Trump administration gets rid of this rule. Your case is now dismissed because it's moot. It no longer is federal law that's being executed, and so you're no longer being injured by it. And the last one is the political question doctrine, and this is another tradition that goes back to Chief Justice Marshall, where the issue here is you can't force the courts to hear a case that is best dealt with by the Congress or best dealt with by the president. So they don't want to deal with political issues. They want to deal with issues that really need to have them stepping in to determine right and wrong. The best example I can think of a political question doctrine goes back to Baker v. Carr and whether or not partisan gerrymandering is something that can be heard in the courts. And so in Baker v. Carr, we established that yes, partisan gerrymandering does hurt people, and it is not necessarily best left to the executive and the legislative branches. However, even establishing that it doesn't violate, that this case doesn't violate the political question doctrine is not necessarily meaning that it's going to be easy for them to come up with a determination of what partisan gerrymandering is. But if the courts wanted to put this to rest forever, they might just say, you know what, we decided that this is something that has to do with politics, and we're not best pointed here, where our position is not here to determine something that should have the representation of the people involved through their elected officials, so we're not going to hear it. So you might hear sometimes people say, oh, it's violating the political question doctrine or any of these other functions here, and that is what they're referring to. So most cases are going to go through the Article 3 court cases. All that's federal criminal and civil suits go through the Article 3. Article 1 cases are going to hear some kinds of issues. For instance, U.S. tax court is an Article 1 court. And the biggest difference between an Article 1 court is they have a very, very specific jurisdiction, like the tax court only hears tax issues, and those judges are appointed for terms. They're not for life. So they have much less capacity to kind of hear cases, a broad spectrum of cases. Most cases, however, that you would be involved in are going to go through state courts, so traffic violations, marriage and divorce and custody issues, and even often cases, land ownership are going to be things that are going to go through the state courts. So most of the time, you're not going to end up in federal court. I really just wanted to show you that the steps of a federal case are very, very complicated. There's pretrial, and then there's when we actually are going to accuse somebody. That's called arraignment, and determine if there's enough evidence to hold them. That's when you would have a grand jury get involved in something. Then you have a trial phase, which is a separate phase, and then there's a third phase to the trial called the conviction and sentencing, which each of these is going to have a separate function here, which is trying to ensure over and over and over again, particularly in criminal cases, that you're getting due representation. And for each of these, both the presentment and arraignment, and then the trial itself, and then the conviction phase are going to have separate juries who are going to hear the case. And again, to ensure that you're getting your due process rights, that you're getting a fair day in court. Obviously, a lawsuit or civil court cases are much shorter. There are, in some cases, juries involved, but not always. And in both cases, you can waive your right to a jury, which it's then called a bench trial. So back in that court of original jurisdiction, so we're talking about our district courts, you are going to find that this is where you see the terms that you're very familiar with. So you see a prosecutor who represents the state, and they are going to bring charges against the defendant. Key thing here is that the burden of proof always rests on the government. We presume that the defendant is innocent until proven guilty. In a civil trial, you're going to see the plaintiff, who's the aggrieved party in the case, seeking damages and reparations for their injury from the defendant. And again, the burden of proof is on the plaintiff here. This doesn't have to be a physical injury. It can be something injurious to your bank account or your property or something like that. Some of the other terms that we'll hear from TV that are alive and well in the court of original jurisdiction are pretrial services. This is the investigation with the often, to see if there should be bail, if you're going to be released to the public in order to prepare a defense, if you're a flight risk, if we need to set bail high because you might be a danger to yourself or your community. That's what our pretrial services are. Then you would be arraigned. This happens before the trial begins in earnest. What happens here is the U.S. attorney is going to present evidence and decide if there's enough evidence to go forward with a trial. And the grand jury, if they don't indict, that means that they don't feel that the charges are sufficiently proven by the evidence, and they will say no, and then the trial is over. We've had some really famous arraignments of cops in the past, 7 or 8 years since 2011, in which police officers who were using use of force on the people in the community. Sometimes people feel as though it's uncalled for and it crosses the line, and often police officers aren't arraigned for these because of a concept known as justified use of force. So that is a place where you might see the grand jury getting involved. And then you've got plea bargaining. Sometimes defendants will, before we actually go to the trial, will enter a plea of guilty to reduce their sentences and to waive the trial and get right to the sentencing phase. And you will also see jury trials. You're allowed to have a jury trial, but again, if you waive your right to the jury, you would have a bench trial by the judge. All right, so the Court of Appellate Jurisdiction is going to be the next step up, and so we find that there are 12 districts across the country, and these 12 districts are going to be regional, and there will be an appellate court that will hear courts of appeal, or will hear cases on appeal. So the right to appeal exists regardless of what kind of case you have, and in the circuit court, which is the next step up, that's our appeals court, they have to hear all of these appeals to look for some kind of mistake in law, some kind of error, legal error here. And they are going to help out in civil, criminal, and also in decisions that are made by administrative agencies, as quasi-judicial agencies like the IRS. The only limitation is that the government can never appeal if they lose a criminal case. That's called double jeopardy. So if they lose, it is over for them in the district court. This is really only something that's allowed for the defense. So the person who files the appeal is going to be referred to as the appellant. It's going to move from the district court or the administrative agency to the circuit court in that region. And they are going to send a brief up that's going to explain the legal errors and how it's affecting the outcome of the case. And they will also send up all of the materials from the actual trial itself. So all the information, the proceedings, the evidence, everything. And that will be combed over in that court, in that circuit court. So in addition to all of that evidence and the proceedings and the minutes from every meeting, you will see that the lawyers who are appealing, the appellant is going to submit a brief that's going to explain or describe the error And it's critical here to remember that there will never be any new evidence or testimony submitted, no jury is called, no testimony from the guilty party is made. This is purely just the lawyers for the appellant and the appellee will stand before the court and they will answer questions that the court might have. They will try to, make an argument of how they feel, what they would like to see happen. But it's an oral argument between really, a couple of lawyers and the judges. And the judges are, whereas in the district courts, they're pretty laid back and they just kind of like call balls and strikes. They redirect stuff. They will allow people to testify and stuff like that. Here the courts actually start to ask questions. And depending on the case, you will see that often there's a panel of judges who will sit what's called en banc, and they are going to pepper lawyers with questions. When they do this, it's called a hot bench. So that really means that you've got 15 minutes to ask, and they can ask any question they want. It's often sometimes, argumentative cases that are difficult for you to answer, but they're there to try to persuade the judges on the panel of which way they want to go. And often, lawyers and depending on the case, sometimes the media will try to figure out, look into the tea leaves and figure out what the justices are going to decide. So the briefs are going to include precedent. They're going to include summaries of earlier cases that have similar legal facts or issues. They're going to argue about the legal errors. And kind of the fun thing here is that when they are appealing a case, there is so much precedent in American legal history that you have precedent that supports both sides. And it can be sometimes really confusing. And if you're a really good lawyer, you're going to find really obscure laws to or really obscure cases to justify your position, not just necessarily the big go-to precedents. But it's also about how well you argue the use of that precedent, application of that precedent in that case. Sometimes it's innovating in a way that hasn't been done before. So the appeals courts, they can affirm or agree with the lower court decision. If they disagree, they will vacate or reverse the lower court's decision and maybe decide for a litigant, reverse that case's decision. Or sometimes they might remand it back down to the court of original jurisdiction and demand a retrial to fix some legal error. Most cases in the federal system don't proceed past the circuit courts. This is where most cases go to die. Now, that being said, obviously there will be people who will petition the Supreme Court to hear a case. And this happens sometimes if there's some kind of legal issue that needs to be corrected that's been rattling around in the background forever and the Supreme Court's just refused to hear the case. Or sometimes because a Supreme Court justice is often charged to help mentor the various different circuits, you will find that different justices have different perspectives on different issues. And so they might counsel their circuits to decide in a certain way, thus causing a split in how to apply precedent. It's called a circuit split. So that's when we need the courts to step in and to correct what a circuit split might be. So there are often 7,000 appeals to the Supreme Court. Of only 100 to 150 are accepted. If it's in red, you need to know it for the test. That process of accepting cases is called the Rule of Four. This is an informal process where 4 Supreme Court justices have to vote to hear a case. And so they will have their clerks look at all of the cases that are applied. Sometimes they have a clerk pool where they will share their clerks, and the clerks will divide up the cases and they will write briefs and they will say, I think this case would be good for you. Some of them don't. For instance, Justice Gorsuch has frustrated some of the members of the court by saying, I don't want to be a part of the clerk pool, and I'm just going to have my own clerks pick cases that I want to hear. So he's actually kind of broken away from some of that precedent and thereby frustrated some of the people on the Supreme Court with him. But they have to have, and they'll circulate the clerks will write the briefs and make recommendations on what should be heard, and these will be circulated between the justices, and then the justices will get together on occasion and they will vote. They will vote on what cases they want to hear, and so they have to have 4 justices agree to hear a case in order for it to be placed on the docket. And the docket's just a list of cases that they're going to hear. If they don't have 4, then it will not be heard. Another thing to note here is that they don't all have to agree on why they want to hear it. So, what this means to us is that the courts cannot be forced to hear a case, even if it's potentially unconstitutional. And they don't necessarily have to justify to anyone why they don't want to hear a case, even if it passes, even if we know it's not a political question, even if it does not, even if it's not moot, even if the people have standing, even if the issue is ripe. And sometimes cases get put on the docket where they say, you don't have standing, you shouldn't be here. And that might be a reason why a Supreme Court justice didn't want to hear the case in the first place. You often will say, there have been plenty of cases recently where justices have said, well, I didn't vote for this case to be heard because this doesn't have standing, so why is this here? And then they're trying to persuade their fellow justices to do whatever they want. So it's really interesting. It can be a little confusing, and we'll talk more about it in class. But I mean, the principal thing here is that if you've got four, you're going to be heard, and you can't force the courts to hear something they don't want to hear. So once you're on the docket, that's the petitioner, the person who asked them to hear this, has petitioned for a writ of certiorari, and a writ of certiorari is a command. So that's what happens is once it's past the rule of four, the courts are the ones who give the command, the writ of certiorari, to the circuit court to send up all the information. The petition is what that losing litigant, the person in the appellate or in the appeals round, has given them. I'm petitioning you. I'm requesting that you issue a writ of certiorari or cert to this to the circuit court to hear my case. Once that information has been sent up, the petitioner and the respondent are going to submit another brief to the Supreme Court that talks about the particulars of their case. Then we argue the case. So oral arguments are in about a half an hour for almost every single case that the Supreme Court hears. On occasion, depending on what's happening, there'll be an hour. But before the date of oral arguments, you will see the briefs will be submitted from the petitioner and the respondent, and special interests. This is going back to the special interest group, are going to submit additional legal briefs through what we call the amicus curiae briefs. And these will bring up other legal issues, other legal considerations, and all of the justices will comb through these with their clerks. They will have kind of what the questions that they want to ask on the day of the oral arguments. And what ends up happening is each side, the petitioner and respondent, have a half an hour. And so they walk into the courts. It's fun to watch. By tradition, Ruth Bader Ginsburg always begins the first round of questioning. What they will do is each side will start kind of have a prepared speech, which I hope isn't long because they will never finish it. Because almost immediately the justices start peppering them with questions. And sometimes they're questions that are content specific. Sometimes they're argumentative. Sometimes they're fantastical. But they're there because they're trying to get the other justices to think about some kind of issue that this justice is concerned about as a result of some kind of decision, either for the respondent or for the petitioner. And so they're having an argument through the counsel that's in front of them, who's presenting their case, whether they're the petitioner or the respondent, for the benefit of the other people on the bench. And so kind of the people on the bench have to make a determination. These 9 justices have to figure out, okay, how do I think this person feels? What perspective are they coming from here? How am I going to counter this? Is this like a legal precedent that we want to establish? And so they're having this full-blown conversation. Again, like I said, it's about a half an hour for each side, and then they're done. The people who are going to present for the government are called the Solicitor General, and the Solicitor General's office has several of them, but there is a Chief Solicitor General who's going to go and always argue for the government in whatever issue that they're talking about. So after the oral arguments are over, then the justices retire to what's known as the court in conference, and that's just the next stage where they are going to go into one of their beautiful wood-paneled rooms. They're going to close the door. No one is allowed in there except for the 9 of them. They are going to discuss the case, the merits of the case. They're going to vote on the decision, and then the Chief Justice is going to determine who's going to write the decision for the winning side. And so what ends up happening here, if we can determine that there is a winning side. So that justice will then spend, the next couple of months with their clerks writing what will become, they think, the majority opinion. and they'll circulate the opinion. They'll comment on each other. Sometimes justices will read what that person's legal interpretation of this decision is, and they might say, you know what, I don't really like this, so I'm going to concur. I'm going to agree on some parts, but the parts that I don't agree with, I'm going to write my own brief that explains my perspective on this issue. In terms of precedent, if you have a majority opinion, but you also have multiple concurring opinions, it makes it difficult for us to determine what is precedent, because this tells you that the courts don't agree on some issue that's related to this. So it's not as solid a precedent if you have multiple different interpretations of the same legal point here that's happening. Okay, so we're almost done, I promise. Then there is going to be a day, this is on a separate day in court several months later, in which the court reconvenes and all of the petitioners and respondents come back into the court, and they are going to have the oral argument or have the decisions read to them. It's read into the record. This tradition of having a majority opinion actually goes back to Chief Justice John Marshall, which reflects the views of a collection of justice and thereby makes precedent more reliable, more kind of like ironclad. And so the majority opinions written in sections reflects the rationale of the majority of the justices. Like I said, there's a concurring opinion when we reach the same decisions but not for the same reasons. When there are multiple justices but you cannot, multiple justices signing on is sometimes called a plurality opinion. A dissenting opinion is someone who's written that is not in the majority and establishes reasons for disagreement. We are going to read dissenting opinions. We've read a couple dissenting opinions this year. It's important because it can become the basis for changing precedent in the future. And a per curiam is an anonymous decision from an entire court where names aren't listed. So what we like to see for precedent, to know what's ironclad precedent, is a 9-0 decision with a single majority opinion. If we saw a 9-0 decision with a plurality where there's like 3-3, 2-2, we would not have solid precedent there. That would be very uncomfortable for us, and you wouldn't see that case necessarily kind of cited a lot, and it would be in question, right? The court's divided here. Even a 5-4 split where you have one majority opinion and one concurring opinion, that's even a little difficult for us to kind of hang our hat on that as ironclad precedent, because we really don't necessarily know if we can trust it. And a per curiam decision also has some issues with it too. So, on our final slide, we think to ourselves, well, what happens next? So remember I told you in the first slide here that courts can't self-enforce their rulings. They rely on the Congress to legislate, and they rely on the president to enforce. So because of this, we call this judicial implementation of law. And judicial implementation of law does not happen by the courts, it happens by the other branches. That is really important for us to remember if we talk about something like, why has it been that there have been so many decisions on desegregating of schools? Obviously, we all think of Brown v. Board. There were 3 Brown v. Board cases from 1954 to 1957. But there was also a Supreme Court case in 2016 that also dealt with a command from the federal court saying you must desegregate this one school in Mississippi. And the reason why is because if the president doesn't agree with some issue that's been determined by the courts, he doesn't have to enforce it. If the Congress doesn't agree with some issue, they don't have to legislate it. And if the governors don't agree with it, unless the president is forcing something like desegregation, like Eisenhower did using the National Guard, unless the president is enforcing it, the states can resist. And actually, we saw during the civil rights era was this time called massive resistance, in which the state governors were like, we don't really care what the courts are saying. They're unconstitutional. They're creating policy through their decisions. We don't agree with it. We're not going to follow. We're not going to heal. We're not going to do what they command. So courts, there's efforts to implement or to influence the courts beyond that. And this is our final slide. I'm sorry. So Again, what does Congress do? They can re-legislate so the legal standards fall within the court standings. They can confirm appointees. They can create or eliminate Article 1 courts to change caseload. Article 1 courts are going to have more influence from Congress because they have regular terms. They can legislate changes to the composition of court structure. They've done that many times. They can appropriate funds to support the mission without altering the salary structure. So if they want to make it difficult for the justices to do their job, take away their clerks. We have the idea of oversight. We have the idea, particularly during the appointment component. We have senatorial courtesy. That's a senior ranking member in Congress gets to determine who gets appointed in their home state. But really, we see that is kind of going away. That's really was a part of it because it was difficult for the leadership in DC to know like what was happening in West Virginia, right? Because they're not really familiar with the legal culture there. The president can appoint judges. They can ask the Solicitor General to challenge laws through appeals when possible. We've seen the Solicitor General's office under the Trump administration has actually reversed a lot of positions that Obama's Solicitor General had taken in the appeals. So sometimes you have the federal government is arguing one position and the Department of Justice is arguing a different position on the other side through an amicus curiae brief. It's crazy, I know, but these things happen. They can use the bully pulpit because really the one thing we should remember is that the Supreme Court's independent, but they don't make decisions that are way outside the boundary of what kind of the rest of the culture wants. And then you've got the states with massive resistance, having the Attorney General initiating lawsuits, and then it's difficult to read here, but linkage institutions use amicus curiae and apply pressure by going public with media, elections, parties, and voting. And so that is it, my friends. We are done. A little bit longer of a video, but this is a little bit more of a detail-oriented unit. So if you have any questions, make sure that you bring them into class. Otherwise, we will see you next time.